Yeah, nothing planned. The wind's still over in London. Like, I mean, I play golf at the University of Michigan golf course. Oh, nice things. Good. Do it. I'll sign that. Thank you.
Yeah. So I'm pretty good.
Yes. Crowd should be. Hopefully. Yeah, it's just something.
Has he been before?
I'll never go to Paris. But
Environment, Great Lakes Energy et al., and Mr. Krieger is an et al. As well. The lead case caption is 20-094 This is the time and date that was set for its amended order of June 20, setting on June 26, 2025, additional status conference. Appreciate everyone being here. Thank you. Mr. Trumbull is our court reporter, or Trudell. I apologize, Mr. Trudell. Mr. Trudell, while we're together today, if anything I'm saying or anything any of our lawyers are saying is not able to be heard, if you could let us know, and we'll try to repeat ourselves or make sure our electronic gear is working. We have this is a hearing that the court authorized both in person and Zoom. And since it was such a short order, I think people are doing both. Dan, do we have, I see 6 individuals on the screen. Are there others in
I thought there was 2 that popped up and disappeared a couple of times.
They realized, oh, Redford, no, we don't want to see that. If that's what the people felt, don't feel badly. I think my children would probably agree on any number of occasions. So, all right. Well, at any rate, what I'd like to do before we get into the reason why we're here is just get appearances on the record, and we'll start with plaintiffs' counsel that are present here in court. If we could have an indication, please. Thank you, Ms. Olmenroad. Nice to see you again.
Good afternoon, Your Honor. Jason Thompson and Paulina Kennedy on behalf of the class.
Hi, Ms. Thompson, Mr. Thompson, Ms. Kennedy. Do we have on the through the electronic process, any plaintiffs' counsel want to make their appearance?
Yes, Your Honor. Kevin Carlson and also Megan Bonani from Pitt McGee and Royal Oak.
Good afternoon, Your Honor. Dave Dubin here on behalf of the class plaintiffs.
All right. From Chicago, the home of Leo the 14th, is that right?
No, right now I'm in Barcelona, Your Honor.
Oh, good. Lord. That's nice. Barcelona is my second favorite city in Europe. It's a great place.
It
I hope-
is.
Good time. I hope you get to see the iglesia, the family iglesia, you know, the unfinished cathedral and all the other wonderful things that Barcelona has to offer. So,
Yes,
right.
saw it this morning.
oh, did you? Isn't that, have they finished it yet in the 35 years since I was there?
No, they're now saying it's going to be another 10 years.
I got news for you. Our good Spanish friend said that 35 years ago. So anyway, okay.
Yes.
Who else wants to indicate from plaintiffs? All right.
Morning, Your Honor. Megan Shannon from Fagan Scott on behalf of the class plaintiffs.
Thank you, Ms. Shannon.
Good afternoon, Your Honor. Kyle Jacobson on behalf of the class plaintiffs with Fagan Scott as well. Thank you.
Good afternoon, Michael Bonvillante from Buckfire Law Firm on behalf of the mass plaintiffs.
Okay. All right. Thank you. And I think that covers everybody. It's Mr. Takala, you as well?
Yes, Your Honor. Thank you. Timothy Tackle on behalf of the plaintiffs.
I got to check my watch. All right. Since it's almost tapas time in Barcelona for Mr. Dubin, we'll make sure we operate with some dispatch today. All right. On behalf of the state of Michigan.
Good afternoon, Your Honor. Richard Cole on behalf of the defendant.
Right.
Danielle Allison Yocum on behalf of defendants.
I see a familiar face on the screen too.
Good afternoon, Your Honor. Nathan Gamble here, also on behalf of the defendants.
All right. Thank you. All right. I appreciate everyone being here today, as does my staff. Mr. Cranmer is providing security for us, and Ms. Husa, one of the one of the attorney commissioners who's assigned to the court, is here as well. We'll follow the same sort of protocol we've done in other status conferences. We'll go through the substance of the vast majority of what I think we need to. I'll take a brief recess, meet with the commissioner, find out if there are other areas that they'd like me to go into. I think each time we've had a few things that they pointed out. It usually doesn't take a whole lot of time. I do not anticipate this is going to be a super lengthy hearing, but I appreciate everybody's willingness to be here today. In the order that I issued setting this hearing, I gave parties the opportunity to submit agenda items. There were 3 that were received. They were all received on June 24th, 2025. The first was received from Mr. Thompson at 7:32 and 37 seconds a.m. The second was received from Mr. Gamble at 11:55 and 7 seconds a.m. And in a very close third, the third one was received from Ms. Olmenroad at 11:55 and 16 seconds a.m. So the batting order for the first, second, and third hitters for the Detroit Tigers today is, as I just indicated. And speaking of, what an awesome year the Tigers are having. So that is, my last year of law school, I graduated in 85 from the University of Detroit and lived with my folks in the city. So I remember when the Tigers went wire to wire, and I remember when they won and going out. We lived 3 blocks off of Woodward, and just the joyous chaos that was taking place after. And hopefully that's a precursor of the late fall in or early fall in the Motor City this year too. So, but it's got to be fun to be in Detroit right now. So first agenda item is from Mr. Thompson.
Thank you very much, Your Honor. Happy to report that through some lengthy discussions. The parties have essentially reached a proposed stipulation and order to certify a class for this phase one of trial. As I indicated in my submission, there's one technical aspect that I want to make sure that we're clear on, and that is whether or not this first phase of the bifurcated trial, the liability phase, you're expecting any proofs as to harm to property. Under the cause of action, of course, that is an essential element, but we're in phase one of the trial.
Right.
So when we read the order, your order references liability. And of course, harm to property could arguably fall under either section of that call. So we just want to make sure today that we hear from you. And depending on what your answer is, I suspect that we'll be able to finish up the stipulation and get it presented to you in short order.
Okay, great. Thanks. Before we hear from me, as I've said many times, I often find that when a court lets the lawyers find the solution, it usually is quicker and more less subject to appellate review, shall we say. Not that I don't like appellate courts, but I have some familiarity with them these days. Anyway, what's the people's position and the department's position on that?
We agree with everything council just said, with the caveat that was explained on the question of what harm has to be shown and what.
Right, okay, and I guess what I would, thank you, counsel. I would not anticipate that during the liability phase, following the discussions that we had a year in 2024, it wasn't exactly a year ago, but that we would be having requiring proof of damages, nor would the plaintiffs not bringing forward proof of damages in any way preclude them to seek damages if liability is found. I mean, that's why I think we bifurcated at the suggestion of many lawyers who were sitting around a conference table on the third floor of this building probably 9 months ago. So my understanding would be that that's how I thought we were going to proceed. So yeah, does that answer your question? Actually, we've got you can hold the microphone. You can be like a rock star or whatever there. Mr. Trudell, can you hear Mr. Thompson when he stays at the table? Test again, Mr. Thompson. I don't know.
Test, Mr. Trudell. This is Jason Thompson.
Can you hear him, Mr. Trudell? Can you hear me, Mr. Trudell?
Okay, there we go. Yeah, we didn't have it on.
He was muted. Can you, what are you picking up?
Here.
You can hear it? Okay, great. Okay, please go ahead, Mr. Thompson.
Thank you, Your Honor. So not to overly nitpick, but it's a big case. It's a lot riding on it. I want to make sure we're clear. When you spoke, you used the word damages. When I spoke, I used the word harm. And this is the debate that we've been having internally. Is there any difference? And let's just make sure that we all are on the same page. When we think of damages, we think of our experts' evaluation of property value, the diminution of property values, for example, or an economic number. Damages meaning an actual testimony as to how much the harm equates to in dollars. When I use the word harm, I'm thinking more in terms of, was there an impact under the taking concept, an impact to plaintiff's property, more of the fact of an injury. Now, when I say it out loud, it almost makes you scratch your head and think, well, my goodness, there clearly was this. The state's even acknowledged that. No one's contesting that there was impact when the dam gave way and the floodwaters were released. Mm-hmm. But if you're really being technical, if you're really looking at the law and the elements of the cause of action for inverse condemnation, which is why we're here, that is an element. And so, the distinction I want to make sure we leave today here isn't just about dollar value, but that we're also not going to be trying the impact that there was harm to plaintiff's property. That's also not going to be part of this first phase. And then I guess what would be left, the question is, it would be the affirmative acts, it would be the abuse of government authority, it would be the remaining elements to the cause of action, just not any requirement that we put on proofs that there was an impact to any particular plaintiff's property or the actual class property itself.
So have you circulated proposed document?
Yes.
All right. Is there any hang up in the language that the parties have agreed to?
That's a good question.
I thought we had, sorry.
Go ahead, please.
I thought we had finalized agreement on the language, so I didn't think that there was anything. If there is anything, it's very light. Nothing that's the order.
Maybe as you go through the rest of the items, Pauline and I will pull it up. My memory is that we did have a little hang up, and that's what led to the discussion.
Right.
We basically used language from Mr. Gamble, who's with us today on the Zoom, that he wanted to use the bifurcation order as the definitional language, which then of course led us to the order where all that we found was the word liability. So we somewhat went in the circle, and I think that's what led us to today. And
I mean, I don't think either Mr. Cool or Mr. Gamble or Ms. House Yoakum are contesting that on May 20th, 2020, people who either owned property or had businesses or were in the physical path of the waters that were released as a result of the Edenville Dam giving way, I don't think any of them have ever suggested that there weren't financial injuries, that there weren't financial damages that were suffered. I don't know. I mean, Mr. Cool or Mr. Gamble or Ms. House Yoakum, do you want to be heard on that or?
No, I mean, you're correct, Your Honor.
Right. I think it's the people's position that, I mean, it's not a stipulation, but it sure sounds, I mean, let's put it this way. If we try this case on liability, we've certified the class, or we've stipulated to a certification, and Mr. Gamble, Mr. Kuhl, or Ms. House Yoakum or the Attorney General of the state of Michigan come in and say, oh, hey, Judge, you got to give us a directed verdict. They didn't have any proofs on damages. It'll be a very short but spirited hearing, I can assure you. So I mean, I don't see it as an issue if you've got the other things resolved, which is great. And I mean, candidly, our law commissioner and I have talked about this. Why aren't they just agreeing to certify the class at this point? So it sounds great. Yeah, we're super happy. I don't know if that answers your question or not.
it doesn't. I just wanted to make sure we had an opportunity to put that all on the record, because frankly, it is a stipulation, to be honest. It's a stipulation for class certification, which means, number one, there will be no briefing submitted to the court on this. If there was an expectation on the court's behalf that we had that proof and we weren't able to stipulate to that, then I would have had to brief that. So I'm happy I'm happy with the record, and we'll proceed to finish the stipulation and tender it to the court quickly.
Thank you.
Your Honor, just
Yes,
for the
ma'am.
record, I just want to confirm that that position of trial applies to plaintiffs, to mass tort plaintiffs as well.
To me, it applies to everybody on that side of the V. That Mr. Cool.
Yes, we agree, Your Honor.
Ms. House Yoakum, you're good with that? Mr. Gamble, in your undisclosed location with the former chief, deputy chief executive of the United States. That does not look like a real background. I'm just going to say that right now. But at any rate, he's actually on vacation in Malaga, just down the Costa del Sol for Mr. Dubin right now. But they're going to meet for tapas later tonight.
Settle the case.
From our perspective, the court's bifurcation order didn't expect a presentation of damages in the first phase of trial, and we didn't expect plaintiffs to make present proofs of damages during the first phase either. So.
Okay, yep, all right, thank you. All right. Mr. Thompson, what else? You were the first filer.
We're done with issue number 1 in my filing. Thank you very much, Your Honor.
Have any additional issues in your filing?
I do not.
Okay, good. Not good that you didn't, but good that I didn't remember it incorrectly. So, all right. We then turn to the second file which was the people's, the defendants, and I'd be happy to open the floor to Mr. Gamble, Mr. Kuehl, Ms. House-Yocum, the Attorney General, if she wants to zoom in. Anybody who wants to appear.
I'll let her know next time she's invited.
Good, that'd be great. Yeah, because she understands. She comes to Grand Rapids fairly frequently, and I just have her run.
I'll tell her. Okay, so the first thing on our list was plaintiff's issuance of a notice of deposition for a Mr. France that was issued well after the factual discovery deadline in this case. Mr. France's counsel has objected to that notice because he was not served as required. He's in Colorado, I believe it is.
Counsel or Mr. France?
Mr. France's counsel.
The lawyers in Colorado or the
both
proposed amendment?
Both, I believe, are actually in Colorado. So they've objected to it, that there wasn't proper service. We've objected that there was not timely served. Mr. France has been known to plaintiffs for a long time. He's been on their witness list forever. There was no reason to wait until after the discovery has been completed. In fact, after we have filed a motion for summary disposition. So we object to any attempts to take the plaintiff's deposition.
Okay. Let's tee that one up.
Can I sit here or you want me to?
Yep, you can stay there. You
I'll
can
move
stay
the mic a
standing,
little
or you can
closer.
stand, whichever is easier.
Okay, first off, we're not precluded from taking depositions. It isn't necessarily a discovery deposition. And the state has
It's
listed,
not a discovery deposition. What is it?
it can be a trial deposition. It can be,
Did you notice it as?
No, we
an
did not.
essay deposition?
We
Then
did
how
not.
can it be a trial deposition if you haven't given proper notice under the Michigan court rules?
well, no, we really haven't decided because the problem that we had is that we were told by FERC that we could not, we were limited in what we could obtain from these witnesses, what would be available. And we were limited in terms of documents. We haven't been able to get documents from these witnesses who have been listed as experts by defendant. We wanted to make a record so that when we move to limit certain portions of any testimony they may have or admissibility of certain issues, that they have precluded discovery through the FERC because it's considered a critical infrastructure. And on that basis, FERC has denied us the opportunity to depose
Brought any motion seeking the court's assistance to go through those, to address those issues?
Not at this point.
All right.
We were intended to file it as a motion to eliminate.
A motion eliminate for what, counsel?
To limit any testimony to issues that were available to plaintiffs. See, FERC will not allow, they will limit what he can testify to. They will not allow him to testify to anything that is a deliberative process. This was a collaborative process, the preparation of the IFT report. And this issue is probably best addressed through a motion practice to explain and to produce the records of the letters we received from FERC. But the court could not order FERC because that would be federal jurisdiction
I can
to.
order anything I want to order. And if a party chooses not to obey my orders, then my friends at 330 Ionia Northwest, where I used to be an assistant United States attorney for the United States Department of Justice, will file a motion to quash or a motion of removal. And then one of my friends across the street, the Honorable Judges Beckering or Bob Yonker or Paul Maloney or Holly Yarbo, all of whom I know, will decide whether or not I've lost my mind, which many of them probably would readily order. But how do we, so.
I misspoke. Of course, the court can order it. It's that FERC will not recognize it. That we've been advised that by FERC, so.
Well, how much time, I can just say preliminarily, without studying any learned response on why the motion shouldn't be granted, I will tell you, I think the plaintiffs have a substantial and with capitalized, bold, underlined hill to climb to not grant this motion. Yeah, we have been together, just me and you all, since February 4th, 2024. We have had scheduled quarterly status conferences. The idea that FERC was involved has been at the forefront from the beginning. The lawsuit was filed 5 days after the dam failed in 2020. I don't know how you get to subpoena discovery. And I don't know how many times I have said, no kidding, I mean it, discovery ends on throughout the course of this. So I will certainly review with close consideration, but I am, and I'm not ruling on it because I will give the parties an opportunity to respond, but
Your Honor, we
Yes.
we had decided we aren't taking the dep. We gave them notice that wasn't occurring. I guess we didn't give notice that we aren't period pursuing it, but we certainly canceled the deposition for the date that it was scheduled.
yes. Did you issue a subpoena to this proposed witness?
My understanding is it was not served.
Well, as you all have listened to my stories ad nauseum, and I'm sure you're pretty bored with them. I probably would be if I were in your shoes. But as I've said many times, my wife says, Jim, one of your greatest traits is you're very direct. Oh, thank you, Dee. Jim, one of your greatest weaknesses is you're very direct. Okay. It's a double-edged personality trait of mine. But I'm just trying to be very direct, Ms. Holman. I'm not trying to be rude. I'm not trying to be discourteous, but and just because you haven't, just because you've given notice that you don't intend to take the deposition on the day that it was previously noticed for, that's not a declaration of, I'm not going to take the dep.
I am making
There's a
that.
motion pending. So if you want to, you and your colleagues on your side of the case are all very capable. I think the world of everybody. But you'll make a decision. Either you're going to withdraw the request for the dep, or you'll respond to the motion.
We are withdrawing the request for the dep.
Oh, okay. All right. Okay.
You know, may I have a moment to add?
Do you want to talk with Ms. Olmerod, or do you want to talk to me?
I just wanted to add to what Ms. Almanrod alluded to, that we have been wrestling with what I'm going to call the FERC issue and the defense, the deliberative process defense for well over a year. Part of the noticing of the deposition we believed was that it was going to be required or could be asked of us down the line as we get to the motion in limine that she alluded to. I don't want you to think that we have come to your court for the last 2 years with plugs in our ears and not listened to you in terms of when discovery ends and things of that nature. There's more background to this that will probably be revealed at a later date, but for today's purposes, we are not going forward with this deposition. Nothing needs to be further done on it today from plaintiff's perspective. But I didn't want you to leave here today with the impression that there might not be more to this FERC issue to come.
Okay, that's fine, counsel.
And it will not be a
There's-
deposition notice.
There is a body of case law, at least when I was with the United States Department of Justice between August 1st, 1990 and May 8th, 1998, when I had the privilege of serving as an assistant United States attorney. And then when I had the privilege of leading the Navy's non-tort litigation in my military capacity in 2 different assignments as an executive and then commanding officer of a number of some of the most skilled lawyers I've ever known in my life. They're called the TUI regs. Whenever an outside party seeks to obtain information from a federal officer, an officer is small o, not big O commissioned, there's a whole body of administrative and procedural and case law in this. We all know that. Every lawyer in the courtroom is nodding. I mean, so this is, these are not surprising issues. These are just issues that throughout the course of litigation, you address. And so, yeah, we'll address whatever comes up next when it comes up next. All right, Mr. Cool, anything, what's next?
Nothing else. We move on to the second issue that we had raised, Your Honor.
Whatever you're ready.
You had asked about motions that are pending. We provided a list of those for you. And we've identified 4. The first is our C7 motion that relates to notices of loss and whether or not they were timely filed. We don't feel the court has to address that issue at this time.
I think,
but we just wanted to make sure it wasn't law.
right.
Put it down.
What I can tell you what I'm thinking about doing on that, well, not what I'm now thinking of doing at the suggestion of our commissioner attorney is to issue a very short order that is, I think pretty straightforward, that says, here are the issues that are before the court as relates to this C7 issue. Because we have split the case on a bifurcated basis, the court is going to hold in abeyance its decision on those matters. Would that be satisfactory?
I don't think we'd have any objection to that yet.
That is satisfactory to plaintiffs.
All right, thank you. Let me just. All right. Mr. Cool, Mr. Gamble, or Ms. Hasiokum next.
Let's see, the second motion that we've identified is our November 26, 2024 motion to determine the sufficiency of plaintiff's responses to discovery. They, in large part, I'm summarizing, they had objected to the discovery or failed to provide responses, saying that.
It's in preparation for our chance to be together today. I reread the pleading that you submitted together with the attachment. And I hear what you're saying, but at the end of every request to admit, don't they say denied?
They have an obligation to provide an explanation as to why. And they haven't done that.
Okay.
Discovery's been completed
No,
now.
I
Your Honor.
hear you, but
That
I
should
mean,
be available to them.
I can imagine see attachments, pages 1 through 2,300 of our reply to your motion for summary disposition. Quote, and then, same. I mean, I don't know, but.
I think the requests are very specific. And so that kind of answer.
Some of them are, but not all are, but.
Yes, I would agree, but most, in our mind, most of them are very specific. And so that would not be an appropriate response. And they're designed really to narrow, that's what discovery's for. That's what we're at this stage. Discovery's been completed.
Right.
And so we need to find out what we still have disputes about. We feel the vast majority of those, there should not be a dispute.
Okay.
And that's why they needed to provide complete response.
Let's hear from Sister Counsel, Ms. Holman Road.
Your Honor, defendants filed a motion. We supplemented our answers. When we answered the motion, we cited case law. We do not have to offer an explanation on a denial. And although we did often include it
When was
within our
your,
objection and
when
explanation.
was the supplement, if you recall?
I don't recall, Your Honor. I didn't realize we were going to actually argue the motion today, just to be aware of the fact that these were
Okay.
pending.
Okay, so it's your position, you've fully complied
Yes.
by the
absolutely.
supplement.
With the supplement, and actually, I believe that to that extent of denial admitted, I believe we complied initially as well.
Okay. Do you happen to know when they supplemented?
I cannot tell you. My suggestion would be is we have a status conference scheduled for August 11th.
Yes.
These are issues, maybe we can argue the merits of this motion at that
Yeah,
status conference.
no, we're gonna be doing a whole bunch on the 11th, so, but that's, added to the hit parade. If you can't work it out between the two of you.
Well, well, we have, Your Honor may remember that you ordered us to have a bi-monthly or bi-weekly, I guess it is, meeting. And so
Yes.
we do that every other Thursday. And so we can talk about what your specific issues are. I'm not certain with the basis of what you're arguing today that we will be able to resolve it, but I think we should make an
Yeah.
effort towards that.
Take a run at it. If you can't get it resolved, then maybe do a joint submission. This is to advise the court, we weren't able to resolve this. We need you to tee it up for the August 11th. Just, and try to let me know, by August 1st.
Okay.
Third issue that we had listed, Your Honor, was our June 6, 2025 motion regarding their expert, Mr. Sturtevant.
Right.
Again, we would suggest, we still have had, briefing has not been completed
Right.
on
July.
that.
I think we gave until July 9th.
Yes.
Right.
Yes. Our request or suggestion is that we put that also up for hearing on the August 11th status conference.
I'm going to have our security sweep my chambers for listening devices because the plaintiff's lawyer and the defense lawyers seem to know what I'm thinking. So, and saying to myself, muttering to myself downstairs, just a few floors below. I obviously look forward to the plaintiff's response on that. Would that be satisfactory to?
Yes, it would, Your Honor.
Okay, I think that's a very good idea.
And finally, we have refiled our motion for summary disposition pursuant to 2.116C10, which, as we explained, different from our prior ones based upon our motion, limiting motion to exclude.
Right.
And based upon a narrowing of the facts. I believe the court has set a September date for the hearing on those. So I don't think we have to have that at the August 11th hearing, but that would be the date for that.
What? So it was filed June 20th. Okay, can we get it? Here's what I would like the lawyers to do on that one is take a look at things and if it were possible to also tee that up for August 11th, I would certainly be in favor of that.
Your Honor.
Mr. Gamble, you have the floor momentarily. Go ahead.
Thank you, Your Honor. We can do that, Your Honor. We can make sure our reply is filed sufficiently long enough before August 11th to give the court an opportunity to review all the briefs. We have no problem with that.
Okay.
Your Honor, originally under the CMO, these motions were to be motions to be filed for July 3.
Mm-hmm.
We believe this is just a reconsideration motion, but nevertheless, they filed it as an SG motion. And if we're following the CMO, our answer is not due until July 25th. And so it would depend if all the briefing can be done in time for the court.
Right.
Because the CMO gave us 35
No,
days.
I understand.
Yeah.
I understand, but we also, issued that CMO, I did not anticipate that I would have already read 3 C10 motions, which I have. One from August, withdrawn, one from September. I'm sorry, one was supplemented. The September one was supplemented, and that's the one I ruled on orally. So yeah, what I would like the plaintiffs to do is among your team, look at it. If you can get it filed or answer filed in a manner that lets them file their reply so that we could tee this up to discuss and argue on August 11th. That is candidly my preference. I'm not going to order it, however. If you can make it work, please do. If you can't, then we will, as they said on Saturday mornings, the cartoons in the good old city of Detroit, we rejoin our heroes. And so we will rejoin our heroes in September if we have to. So
They kindly filed their brief, Your Honor. We'll be able to get it done.
thank you. Yeah.
And we will do our best to do, but, next week's a holiday week and so.
We're going to be talking about calendars and
Yeah.
days and months and stuff once I take the floor. So yeah, I understand.
Thank you.
Okay.
That was it for the motions that we had identified in ours. We had also talk about trial schedule, one of the issues that we'd identified. And we first had this discussion, just thinking about it, I think we had given the court thought that it might take several weeks for a trial.
Yeah.
And it's based upon the court's narrowing of the issues. Now we'll talk about really a very specific intent.
Why? I read with some interest, well, I read with some interest all the pleadings in this case, but there are a number of statements throughout the pleadings by the defendants since the court issued its order denying the C10 relief. And I'm not sure the C10 denial it means everything that the defendants seem to think it means. As far as now, that's not an issue. Now that's not an issue. I went over in my mind whether or not to use this analogy, but I'm going to. You can have a seat, Mr. Cool. Yeah, I won't use the analogy. I don't need to belabor it. The point is, the plaintiffs had the burden of proof by showing by lawful and competent evidence that the elements of an inverse condemnation have taken place in order to survive a motion for a directed verdict at the close of proofs in their case. Because as a matter of law, the denial of a permit cannot be the, air quotes around the word the, basis for an inverse condemnation, I don't know that it can't be some evidence in addition to other evidence that the court would be obligated to weigh, measure, and consider. In civil jury trials, as all of us who in this courtroom have had the privilege of either representing parties in civil trials or adjudicating over them, the civil jury instruction on evidence. Ladies and gentlemen, you're only considered the evidence which has been properly admitted in the case. The evidence is what I've told you is evidence, or it is the exhibits or the testimony. You may believe all, some, or none of any parties, witnesses and testimony, and give that evidence and testimony the weight that you believe it deserves. So yes, I understand the people's position, but I'm not sure I hear you, and I think it's important, but I'm not sure it means we're not going to hear any of that. So I don't know if the case is that much shorter, I guess, is what I'm getting to.
And we understand that, and I guess our point is the comments that were made us relook at what are going to be the actual issues for the trial, and they are very limited. In our view, they are very limited. And so if this court enforces those limitations and limits evidence to relevant topics on these elements, and it's gonna be a much shorter trial, correct?
Okay. All right.
Like, that's our overall plan.
Thank you. Okay.
And Your Honor, if I may, this is Mr. Nathan Campbell. The element of the court's ruling on May 12th that caught our attention was the court's confirmation, really, that a failure to issue an order, a failure to act, cannot form the basis of an inverse condemnation claim. And the reason that caught our attention is because during the course of discovery for the past year or so, from our perspective, the plaintiffs have been trying to develop a case that the defendants are liable for the dam's failure because they failed to issue an order to the dam owner. And by confirming that that failure can't be the basis of an inverse condemnation claim, from our view, it simplifies the case. And we weren't asking that the court enter some sort of order formally changing trial dates. We just wanted to introduce the court to the idea that really that confirmation from the court on May 12th simplifies issues quite a bit. If we're just focused on the elements from the Court of Appeals opinion, it'll be a much shorter trial.
All right. Thank you. Plaintiffs wish to be heard.
Merely to echo Your Honor's observation that it may not be sufficient to form the cause of action or the taking, but to the extent Mr. Gamble has left that distinction off or Mr. Cool has ignored that, we disagree with them. I don't know that the trial has been shortened 1 minute because of the ruling. And so if they think it's shorter, that's wonderful, but we don't see it at all.
Okay. All right. Thank you both, all. Mr. Cool, anything else?
I think that was the end of our agenda. Anything else?
No.
Nate, anything else?
No, nothing more. Thank you, Your Honor.
All right. We turn our attention then to our third filing, which was received at 11:55:16 by Ms. Ullman Road. You have the floor.
The issue is the timing of the final pretrial order. The court indicated that it would be issued in October. And I talked with defense counsel about this. We're a little bit concerned with the holidays that, and the amount of work that's going to have to be done. And then we start running into Thanksgiving, we start running into Christmas, and we're going to have a lot of meet and confers to try and narrow this down. So on some of the more logistical, we understand until you rule on the final motions, the court may not be able to issue a complete pretrial order, but on some of the, what I call like exhibits, logistical type items, if we could have a pretrial order so we could get started on it a little bit sooner than October, we'd really appreciate it.
I think you're going to get it a whole lot earlier than October.
Okay, thank you.
So, both Ms. Hughes and I have been talking about this, and it's and I'm going to talk about some of my concepts when I get to my turn. But you're going to have an actual order before August 11th. You're going to have something. It's not going to be next week probably because it is a shortened week, and I have summary disposition hearings in, I think, 2 cases between now and next week, now and the end of next week. But yeah, yes.
Thank you.
Your wish is my command.
Thank you. Item number 2 was already discussed as part of Mr. Thompson's presentation. That's resolved. The third thing was the motion for summary disposition, and I think it's been discussed to the extent. I just wanted to make sure that our due date is still, well, the court would like us to expedite it. Originally, the idea was that within the 35 days, not the court, not under the local rules, but under the 35 days in the CMR.
I'm going to give it to you because that's what I said in my original order, but we've already talked about hopes. What is it? A hope or a dream without a plan, a hope without a plan is just a dream. So I have a hope, but if we can get it, no, listen, everybody, people, if you were to study this case in a civil practice case book, there'd be many, many, many examples of how the trial judge should do a better job than what I've done. There are lots of examples of how to do your discovery and exemplary briefing that the plaintiffs and defense have had, but there's lots of examples of everybody's working hard. The court's working hard. The lawyers are working hard. Our staff is working hard. we literally have had multiple meetings with the staff's IT department, with the staff's physical plant people. We even had the court's finance guy come over here because we're going to have to spend some dough to get this courtroom in the right shape for us to have as many people. So I know everybody's working hard. So I'm not going to belabor that.
And I can't commit further because neither Mr. Thompson nor I are the primary drafters of our response, so it would be unfair.
I understand. Okay. All right. Before we turn over then to what I had on some of my matters, anything else, Mr. Thompson?
Nothing, Your Honor.
Ms. Alman Road?
Nothing further, Your Honor.
Any of the plaintiffs' counsel who are with us electronically, anybody have anything else other than Mr. Dubin? Because I'm wildly jealous that he's in Spain right now, after having lived there. And the coffee cup that I have today, Mr. Dubin, says U.S. Naval Station Rota, Spain, where I was stationed for 2 years. And I've thought an awful lot about it in the last couple of days, actually getting ready for this hearing. And I'll talk about that in a minute. But Rota is just past Gibraltar, about 100 kilometers up the coast of Duluth, not the coast of Del Sol, but the coast of Duluth from Gibraltar. So you don't get to say anything, Mr. Dubin, but if I were to let you say anything, would you have anything to add?
I have nothing to add. I think council who are there have done a marvelous job. So.
Yep, good. Anybody else on the plaintiff side want anything to say? No one. So indicating, okay, Mr. Gamble, Mr. Cool, or Ms. Allison Yocum, anything you want to add before we go to the court's checklist?
No, no, sir.
Nate, anything from you?
No, Your Honor, thank you.
All right. Well, I hope you and Mr. Dubin enjoy the coast of Duluth this afternoon, but the rest of us will be back here in Michigan. Okay. So let's talk about some of the things I've been thinking about. Well, the first thing I do want to say, and I commented about my mug from Naval Station Rota, Spain. I was a 27-year-old judge advocate, married, baby, flying around the Mediterranean, Persian Gulf, North Atlantic, trying cases. And if somebody would have told me when I was 27 to 29 years old that 35 years later, I'd have the privilege of serving on a court like this with great lawyers like this, I would have told them, you're completely outside of your mind. You know, I'll never be able to do something like that. So I will confess there are times when I seek to fulfill my statutory and constitutional duties in this case that I become tired and sometimes even frustrated. And when I look at that mug, I have to step back and realize what a singular privilege it is to be a lawyer in the first place, but to be able to serve the parties in this case. So I appreciate what everyone has done and the hard work. And I'll encourage us as we seek to get to a final resolution in this case, one way or the other, I need to remind myself of what a privilege it is to be a lawyer in Michigan or anywhere else in the United States. But I encourage each of you to think about it too. I don't know why, it really struck me. And then when I saw Mr. Dubin, I decided I wasn't going to talk about it. And then when I find out Mr. Dubin's in my second favorite city in Europe, which I got to go to in a U.S. Navy port call back 100 years ago, it made me want to talk about it a little bit. So anyway, I think everybody's working super hard. I'm very appreciative of it. And I think everybody's working super smart, so we've good lawyers working hard. I want the parties to understand, and this isn't a Jimmy Redford pity party, but I want you to understand what I've got in addition to this case. We have 6 months between now and December 31st. I have 6 case calls, 25 cases, each call, 150 cases. I will have the primary responsibility of writing 50 of those opinions and orders, not opinions and orders, opinions in full-on appeals. Some will be published, some won't be published. Every single one of those cases is singularly important for those litigants, just as this case is for everyone here. In addition to that, I'll be on the motion docket for 4 months for an additional 240 cases. I have 2 trials scheduled right now, and just has been filed an injunctive relief case related to the building code of the state of Michigan, where an emergency hearing is being sought before August 27th, and the implementation of new rules. I have two other Court of Claims trials. One is 2 weeks long in December, and one is going to be a 1 to 2 day trial in either August or September. That means a minimum of 46 days, working days, I am not going to have between now and December 31st to work on this case, at a minimum. There are 121 days, working days, between today and December 31st. So I have 75 working days to deal and to have the privilege of serving on 150 other full-on appeals and 240 motion cases and all the other Court of Claims responsibilities. I don't say that to say, feel sorry for me, my life is sad. It's not. I am the luckiest person I know from a personal perspective, from a family perspective, from a everything perspective. But I'm telling you this because it is going to be impossible for me to digest motions that have 2,000 pages attached to them that are 50 pages long. So from this point forward in our litigation, you're going to get an order to memorialize this. No motion or brief may exceed 20 pages, period. Between now and when we finish the liability phase of the case, if a party absolutely, positively feels it cannot humanly be done to keep it to 20 pages, you may seek leave 2 times. You don't get to seek leave a 3rd time. So if it's that singularly important, and I'm saying these things on the record because I want my colleagues on the Court of Appeals, when they're reviewing my decisions for an abuse of discretion, so the Court of Appeals understands I'm not making this decision lightly, and I'm not making it out of disrespect to these superbly capable lawyers, but it is simply about the finite universe of time between now and when this case is going to have to go to trial. So 20 pages, and absent exceptional circumstances, attachments are limited to 100 pages. 100 pages. We already have at least 2,600 pages in attachments to the summary disposition motions that have been filed and to the answers. You can cross-reference those in your submission, but you don't have to. I know we don't get printed materials anymore, but let's not beat up those electrons. Let's just, tell us where it is. Tell us where you want us to look. So those are going to be part of my scheduling order. As we're moving forward, I'm going to indicate to you in the order that Ms. Olmenroad was talking about when trial briefs are going to be due. I'm going to expect trial briefs on or before December 15th. December 15th. I'm also going to expect exhibit books, and in the trial scheduling order, you're going to receive what an exhibit book is going to look like by December 15th, 2025. I am also going to require, and I want some input from both sides of the case. Everybody needs to know who's going to be called. Plaintiffs, I want to know when you will be in a position to tell the court and to tell the other side who it is you intend to call for actual trial in this case. What's your best guess? When could you be ready to communicate that?
I'd say in September.
September?
Yeah.
That sounds
Oh,
reasonable.
okay. So if we said October 1st, that would be plenty of time.
Absolutely.
Okay. All right. So if the plaintiffs can do that, the defense, if plaintiffs can say by October 1st, here's who we think we're going to call. And in the scheduling order, I'm going to have a little chart for you because I'm a visual person. And it's going to be, who do we expect? And let me ask you, I'll negotiate with you on this. what I would like to have, okay, the witness list by October 1st, by the plaintiff's defense by October 15th, if that's a Monday. Okay.
It's fine.
When you submit the trial brief or the trial bench book or the exhibit book, whatever, I'm going to want it to show, here's our batting order. And I want an estimate from whoever's calling the witness. We think our testimony from this witness will be 2.5 hours, will be 6 hours, will be, Lord forbid, 8 hours. You know, I can't imagine anybody's going to take 8 hours. And then once you receive that from the other side, I'm going to want the defense to say, you're going to have a chart. There's going to be a place to fill in the blank. We expect our cross, our primary cross is going to be, half an hour, 20 minutes. And plaintiffs, once you get the defendant's witness list, same thing. And this is so we can all sort of try to calibrate ourselves to move forward. I've got 4 weeks blocked out for this. As of right now, it's January. So we start 12 January. That week, it's 5 days. 19 January is the Dr. King holiday week, 4 days that week. 26 January, 5 days. And at this point, the week of 2 February, 5 days. The only asterisk on 2 February is this courtroom is the courtroom of the Michigan Court of Appeals. I'm going to be asking, we set roughly our schedules in the fall. I'm going to be asking that the Grand Rapids case call for the Court of Appeals be the next week of February, not the first week of February. That request, maybe, sure, Jim, we'll do what we can to help you. Or maybe, what are you kidding me? You can take a week off and then go a week later. You all will know the same time I do. But right now, that's what I'm anticipating. So those are sort of some of the logistical things that I wanted to let you know where I'm at and sort of a forecast of where some things that'll be included in a trial management order, an interim trial management order, if you will, that'll come out probably on or before July 15th would be my expectation. Looking at my other notes. And I guess I would encourage, the lawyers, or at least somebody on each team. Every lawyer doesn't have to do it, but I think it would be, I know when I was a trial lawyer, I always tried to talk to friends or colleagues or professional acquaintances who had actually tried contested cases to verdict in front of judges that I was going to try in front of. I would encourage you to do the same to other practitioners for the in excess of 200 trials I had the privilege of presiding over in the 17th Circuit. You could probably make a FOIA request and find out what my military trials were, but because the military is so fluid, it'd be hard to find those lawyers. But and that was a long time ago. Well, it was a long time ago that I was on the trial bench too. So, but I'd encourage you to do that because I think they'll give you an indication of, completely irrational, never prepared, don't know what to expect to, reads everything you give them, may not be the brightest bulb on the tree, but he tries hard, whatever it is that they're going to say. That's just advice I'd give to any lawyer. I don't think I need to, given the quality of the people in this case, but I think it could be beneficial. All right, those are some of my notes. One of the other things I wanted to ask about, I've already asked about motions. We've already talked about discovery. In my order that I issued scheduling today's meeting, I said I was going to inquire about the status of facilitation and or mediation. And a status can be, we're not doing anything, or status is, we're super interested, but the other guys aren't, or the status could be, we're all interested. So starting with the plaintiffs who have the burden of proof.
Your Honor, at our settlement conference with Judge Murray, he indicated that he was going to give you a report. And I don't know if that's.
Received a report.
Okay. And so we did not file one either separately
Oh,
or
no,
jointly
I
because.
wasn't expecting you to
Okay.
file anything, any type of report saying here. And I will affirmatively say, I have not received any any physical document from Judge Murray or any statement from Judge Murray which states, here's what we're asking for, or here's what we would be willing to. I have received no numerical statements of any kind whatsoever, nor would I anticipate that I ever will. You know, so, you know, because that's why we don't do our own settlement conferences, because we're the trier of fact.
But we understood he was going to let you know that it had transpired and there had been an order.
Yeah, my
suggesting.
understanding was the plaintiffs were willing to continue to talk and that the defendants basically said, we're not interested at this point. I don't know if that's a fair summary. Mr. Gamble or Mr. Cool or counsel, I don't know. So is that, you know.
Plaintiffs are always open to discussing resolving the case. We would like the case to be returned to Judge Rosen. We believe that he has effectively resolved hundreds of cases. And the defendants agreed to him as a mediator originally. That was a joint stipulation. I actually filed a motion with a proposed order of, you know, the type of empowerment that the mediator would need to try and move this forward.
Okay.
And the court, I think in response to the settlement conference, but.
Right. Okay.
Your Honor, I'm gonna be frank with you. I don't think based upon the numbers that we're talking about and financial straits that the state is currently in, budgetary issues that it's facing, that they're going to go.
Okay. Appreciate candor always. I guess. Wait a second. I think I've talked about this previously. I'm going to talk about it again briefly. When I was in private practice, we had a partner who was responsible for one particular piece of business with a particular set of clients, big part of our practice. And whether you were a 5-year lawyer, 15-year lawyer, or 25-year lawyer, if you were assigned a case in this practice group, you had to work with this very senior lawyer who's now passed away, but just an iconic attorney in Michigan. And he would, and when you have this meeting, you'd have to give him a written summary. You'd summarize your salient witnesses, salient claims and defenses. And this would be whether it was when this was defense, but it would apply with equal currency to plaintiff work on a case as well. What's the nature of the claim? What's the best case scenario? What's the worst case scenario? What's the most likely, value, financial value? And then what's your likelihood of success and what are the risks? And then you'd plug it in and then that'd be the settlement value of the case. And 9 times out of 10, more than 9 times out of 10, it was spot on. And as a circuit judge for 12 years, when I did settlement conferences, I approached things basically the same way. And I'll bet certainly in excess of 80% of the case I did settlement conferences on settled. And nobody likes to settle cases. Everybody is unhappy. And what I would always tell the parties was my goal today when we meet is that everybody leaves here unhappy, because that way it'll mean compromise. I understand the statements made by Mr. Kuhl, understand the statements made by the plaintiffs. In a case as many parties and as many issues and as many life stories that are affected by it, because every single person, whether you were a employee of a department who was monitoring these things, or whether you're a riparian property owner in a third generation, where you have a place you went to and you open a business 3 months before this all happened, everybody has a story. There are thousands of them, and they're all serious on both sides of the case. But if there's going to ever be a resolution that can be worked at, what I would invite the parties to think about, not just what I talked about, this formula, this one managing partner did, but try to, in your own mind's eye, define what does success look like? If other than inventing a time machine and going back and making it so this doesn't happen, which we can't do. But what does success look like? And I'm not sure success always looks like X number of dollars. Maybe it looks like a restored something that's holding back water. Maybe it looks like businesses that are able to go forward and to be compensated for some of their damages. I don't know. And maybe those, whatever those numbers are, and where can those resources come from? And it may not, the likelihood of resolution may not be as grim as everybody in the courtroom and on the call thinks it is. And I'm an inherently optimistic person. And I think, keeping expectations realistic on both sides is imperative. Let's assume this lawsuit never happened. What would success look like to resolving this very difficult situation? And if it's a Venn diagram, where does success without a lawsuit and success with a lawsuit, where would those things intersect? And my guess is there would be a whole lot of overlap. And if that's so, maybe a facilitator like the Honorable Judge Rosen could actually move you in that, help you move in that direction. So anyway, I'm not going to order it beyond what I've already ordered, but I think it would be prudent, because I think whether you're the department, the state, or the plaintiffs, a negotiated resolution is often, that doesn't get you everything, and that by any means, if you're a plaintiff, and that gives up much more than you wanted to if you're a defendant, often ends up being that which is in the best interest of all the litigants. But I'm not the facilitator, I'm not the settlement, I'm the trier of fact. So those are my observations on that. But I appreciate both counsel's candor in the representation of their respective positions. Okay, let me take a quick look. At my notes. Mr. Cool, as relates to your motion, your side's motion, of June 6th regarding Mr. Sturdivant, is that actually a Daubert motion?
Well,
And part of, yes, it is. The second part, the first argument is obviously the report was written by plaintiff's counsel, and therefore it should not be permitted.
Okay.
The second part of the argument, which goes through, is he really an expert? Does he have a factual basis? Yes, I would say that falls well within Rule 7.
Okay. What's the plaintiff's thoughts?
Plaintiff's position is that the entirety of the motion is a Dauber motion. They're challenging the report. They're challenging the expert. That's a Dauber motion. And we contest their view of some of the issues, many of the issues. But I don't see the need to break that down here for this purpose.
Right. Well, the only reason and I've got, well, just like you all have many pages. Excuse me. Many pages of notes in preparation for today's hearing, as I can, all the lawyers are so smart, they didn't need to write notes, but I did. But at any rate, what I'm doing now is I'm looking at my calendar. All right. I'd like counsel, to the extent you're able to try to block out August 22nd, which is a Friday, and August 25th, which is a Monday, and a whole day for purposes of, if on August 11th, we all conclude that I conclude, after listening attentively to each of you, that I can't rule on the people's, and I hope nobody's offended when I say the people. It's just, I'm used to referring to the state. When the state of Michigan is on one side of the V, it's usually the people up. So I know that they're representing the department. I know that so I'm not trying to imply any, that I'm looking at the 10 millions of citizens of Michigan standing on that side. I'm not. I'm just, it's habit of 16 out of the last 20 years being a trial judge. Okay. If we need to have a Daubert hearing, so that would be, bring in, if you're seeking to introduce it, we'll need, obviously, the witness here. My expectation would be the witness would be present in the courtroom, not testifying by Zoom, but present in the courtroom. Mr. Sertivant, and if the defense wanted to bring their own expert in rebuttal, that person would also be expected to be notified the opposing side who you would call. And that person would also be expected. I'm putting those dates out there right now because as I look at my phone, which is often of little value, let me see if I can pull up my iPad calendar too. All right, at least as I can tell right now, both the 22nd and the 25th, the week of the 22nd, I know already is a short week because I'm at a conference for the first 2 days of it. But the 22nd is available, 25th on my calendar is available. Given that where in the month that is, my guess is this courtroom will be available, but I'm not 100% sure on that. So if, when you all get back to your respective offices, if you find out, oh my gosh, there's no way Mr. Campbell and Mr. Dubin are still going to be in Spain at that point, then we'll need to pick other days. But in all seriousness, if you talk to each other, what, your next meeting is scheduled for next Thursday?
I believe it is.
Okay, so as you're preparing for your fireworks celebration on July 3rd, you all caucus among one another. Hey, if we do need to have a Daubert, are the dates that the court talked about, the 22nd and 25th, will they work? Just let Mrs. Tomet know. And tentatively, I'll lock those two dates out for myself. But and you don't have to tell me on July 3rd, just, when you get back after the 4th of July holiday, just give us a call that following week. And if those dates don't work, see what days might work for you and see if you can come up with, maybe 2 days, 3 days that work, sometime before the middle of September, that we can hammer this thing out. Okay. Does that sound satisfactory to the plaintiffs?
I will reach out to Mr. Sturdivant. He's in Colorado.
Right.
And for his availability for those
Sure.
days.
No, that's why, I don't need an answer now, but I'm putting dates out so we can sort it out. That sound okay?
Yes, it does.
Sound all right?
Yes, Your Honor, that's great. Thank you.
Mr. Gamble, sound okay to you?
Yes, Your Honor. Thank you.
Okay, good. All right. We're going to take less than 5-minute recess. Just everybody stay in place. Let's keep the video line going. I'm going to go into the court's roving room, ask Ms. Husa if there's other things that she thinks that I should address that I haven't, and I'll be back as quickly as she and I are done talking. Thank you. We're in place in recess. Thank you. Yeah, just a second. All right, just so, what do the plaintiffs, on the 11th, in addition to our usual get together, what are we going to be arguing? I know we're going to be arguing the Sturdivant motion. What else do the plaintiffs think? Oh, and then we're going to be discussing, so we'll do Sturdivant. The request to admit if we're not resolved by then. What else? Oh, and by the way, we're back on the record. Sorry, Court of Appeals. We were off the record from about 3:15 to about 3:18. That's what I'm calling it. Mr. Thompson, Ms. Alman.
I'm looking through my notes and I don't see anything that's jumping off the page.
The court,
But-
the court mentioned moving up the SD argument from September.
Yeah,
15th.
and SD, if it's fully briefed, SD, if,
Okay.
okay, thanks. Yep. And then, hey, okay, what about defense?
Your Honor, nothing in addition.
Okay, that's what my understanding is too. And then we'll, same sort of order of march as my Army friends used to say for issues, if you have them, in agenda items, whatever the schedule order said, same thing, on this one coming up. All right. Before we recess, is there anything else from anyone who's attending electronically that you'd like to bring to the court's attention? All right. Mr. Dubin and Mr. Jacobson, your mics are off. Did you want to say something?
No, I appreciate you getting this resolved in time for Tapas. You're welcome to join me. I will hold a seat for you.
My dad was a Division I tennis player. Regrettably, it's apparently a generational or multi-generational skipping gene. So far as I'm neither the golfer nor the tennis player that he is, but hopefully at least I'm close to the fly fisherman that he was. So good luck. Enjoy it. Mr. Jacobson, anything?
No, Your Honor. Thank you.
Okay, thanks. For plaintiffs in courtroom,
Nothing, Your Honor.
Nothing, Your Honor.
counsel, anything? Okay.
Nothing,
That's,
Your Honor.
all right, Mr. Gamble.
Nothing from me, Your Honor. Thank you.
All right, thank you. The time is 3 minutes, 23 minutes after 3 p.m. Today is the 26th, I think, of June. Yep, June 26th. And the court is in recess. Thanks for everybody being here. Thanks.
Thank you.
Please go about your business. Thank you. Okay, we're in recess. Thank you.